All right, so you had a choice and you chose to save $10 over potentially something horrible happening to your child. That's basically what you did.
Welcome to one of the most jaw-dropping cases you'll see in a Texas courtroom. Imagine this: a mother, faced with a choice that could define the rest of her life, saving $10 with a coupon or safeguarding her 3-year-old child. And guess which option she picked? Today, we're diving into the shocking case of State of Texas versus Jiz Brown. What begins as a plea hearing quickly unravels into a heated exchange filled with contradictions, questionable parenting decisions, and a judge who isn't holding back. Stay tuned, because the deeper we go, the more disturbing this case becomes. You're about to see how one $10 coupon almost changed a child's life forever, and why the judge couldn't let it slide.
Texas versus Julexis Brown. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Valerie Hetland for Alexis Brown.
And are you Ms. Brown?
Yes, ma'am.
Counsel, have you received all of the discovery?
Yes,
And did you review it with your client?
we did.
Court will find that the state is in compliance with discovery. Ms. Brown, did you review the document entitled Application for Deferred Adjudication with your attorney?
Yes,
Did you
ma'am.
understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment?
Yes.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, we are.
Ms. Brown, did you review the document entitled Court Admonishments with
Yes,
your
ma'am.
attorney?
Yes, ma'am.
Did you understand it?
Yes,
Did you sign it in all the appropriate places?
yes, ma'am.
Did you understand you're charged with the offense of abandoning a child with intent to return as a state jail felony? Range of punishment is
Right here, the judge is reminding Brown that abandoning a child isn't just a bad decision. It's a state jail felony. That means up to 2 years behind bars and a fine as high as $10,000. Think about that for a moment: 2 years of your life, gone. All for a choice that could have been avoided with basic common sense. This isn't just legal jargon. It's the court making it crystal clear that protecting children is non-negotiable. Would you say this punishment range is fair? Or do you think it's too harsh for what happened?
anywhere from 180 days, up to 2 years in the state jail facility, and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yeah.
Ms. Brown, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Ms. Brown, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state recommends deferred adjudication, and you're to follow any and all CPS directives. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes, Your Honor.
All right, so with regards to following any and all CPS directives,
Here's a subtle but important moment: the judge pushes back on the plea deal language. Instead of any and all CPS directives, the judge insists on narrowing it to CPS compliance. Why? Because wording matters. Broad language could give CPS unchecked power, even beyond what the law allows. This is the legal system at work, making sure a defendant's rights aren't swept away under vague terms. It's fascinating, isn't it? The tiniest phrase in a plea agreement can completely change someone's future.
As someone who's practiced on the CPS side, I think that may be overly broad and it may potentially interfere with the representation that her attorney has. So maybe if y'all just said CPS compliance.
Absolutely, Your Honor. We're happy to make that notation.
And just for the record too, the CPS case was only investigation. It didn't go to the 252, it didn't go to family base, and it was closed.
Okay.
So it shouldn't be a problem.
And I'm just asking if they put CPS compliance, because if you have a CPS attorney or they become involved in this case on that side, they may want you to do specific things or have objections to specific things. You're welcome.
Judge, I had to move the stanchion up, so I'm not as thin as I used to be.
All right, and then so there's to be CPS compliance if applicable. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there many such motions?
No, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offer states 1 and attachments.
No objection.
All right, state, you may be excused.
Thank you, Judge.
Did you review the document entitled waiving consent to stipulation
Yes, ma'am.
of testimony and stipulations with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Just, Judge, she regrets, she understands what she did was wrong. There's no minimizing what happened. She was going to the store to get diapers. It was late at night, right before they were going to close. There's some disputes among the times in the report on how long she was gone. She did have a nanny cam there, not to excuse the risk that she put her baby in, but her daughter was asleep. She was watching her on the nanny cam.
Notice the defense strategy here. They're leaning on the nanny cam argument. She left the child asleep, monitored on camera, only gone a short time. But here's the reality. Technology doesn't babysit. A nanny cam can't put out a fire, stop a burglar, or comfort a crying toddler. It's a weak excuse and the judge knows it. Let me ask you, would you ever feel comfortable leaving a 3-year-old completely alone, no matter how good the camera was?
Came back, and there's also some custody child support issues. So the husband or the ex, her daughter's father, had been there at the house waiting for her to leave, and then he had called the police, Judge. So she's not here to make any excuse for what happened, and definitely knows better.
How old was your child when you left?
She was 3.
Okay, so you left a 3-year-old by themselves at night. And the guy that you're living with, what is his relationship to you?
He's basically just my boyfriend right now.
He's your boyfriend.
Fiance, but
So your fiance boyfriend, according to the stipulations, you left to go get diapers?
she was on her last diaper.
No, I need to say yes or no.
Yes.
All right, so you go to get diapers and your boyfriend, Adam Hernandez, does he love you?
Yes, ma'am.
Does he love your child?
Yes.
Then why does it take two people to go get diapers and leave a 3-year-old unattended?
There's no,
There is, I mean,
Yeah.
she does have.
No, tell me why. I want her to tell me.
Explain the.
Like, why? Why would two adults who claim to love a 3-year-old leave a 3-year-old by themselves while they went to the grocery store or wherever store they went to get diapers? Why does it take two adults to go do that?
if I go by myself, I get harassed wherever I go. I know it's no excuse, but the HB that I was living at nearby, there was a guy that.
So why
works
couldn't he
there.
go?
Because we just didn't have enough money. The coupon expired after that night.
So I
and-
don't understand. You don't have enough money
Yes, ma'am.
and the coupon was going to expire.
Yes.
So there are
that's it.
two adults. Why does it take two adults to go pick up an item from a store? I don't understand.
And here it is, the breaking point. The judge lays it out plain and simply. You chose to save $10 with a coupon over your child's safety. That's the kind of decision that stops people in their tracks. On one side of the scale, diapers with a discount. On the other side, your child's life. No parent should ever need the judge to spell this out, but Brown's decision forced the courtroom into this exact moral showdown.
So, if he would have gone, he would have not used the coupon. We wouldn't have had enough money. I mean.
Well, so let me just tell you the choices that you're making. You had a choice. Leave my 3-year-old by herself. Maybe the apartment's complex is going to catch a fire. Maybe somebody's just walking down the street and they notice a 3-year-old and they're like, oh, this would be a great 3-year-old to come take. So that's what you were looking at. And then on the other hand, I can save money by using a coupon. And you chose a coupon. And how much money did you get off for that coupon?
It was like $10 off.
All right. So you had a choice and you chose to save $10 over potentially something horrible happening to your child. That's basically what you did.
Yes, ma'am.
And so I still don't understand. And CPS, they do their own things sometime. I still don't I don't understand why this wasn't a legal case. And two, still don't understand why you have two adults in a household and they decide it takes two people to go pick up diapers and you all are leaving a 3-year-old by themselves. And not only are y'all leaving them by themselves, in the police report, it says the door was locked and it's a reverse lock. So 3-year-old is locked in a room and the only persons who can open that door are the two adults.
Yes, ma'am.
And we're going to unpack that suitcase in a little bit, but I'm still back to the point. I don't know if she understands the danger. And I don't know if the CPS worker stressed the danger that her 3-year-old was in by two grown adults acting as though one person can't go to the grocery store by themselves. Are you even internalizing how that sounds?
Yes, ma'am. I know it's.
You all can leave a 3-year-old by themselves, but you all adults can't go to a grocery store by yourself. Do you understand?
Yes, ma'am.
Now, why is it that there are reverse locks?
This detail is chilling. The reverse locks. By flipping the locks, the child was effectively trapped in the room, unable to escape in an emergency. The judge points out the horrifying possibility. If a fire broke out, no one would even know the child was there, and even if she woke up, she couldn't escape. What was meant as safety turned into a dangerous setup. Sometimes the most dangerous mistakes are made with good intentions, but in law, intentions don't erase the risk.
In that place.
When we moved in, the locks were on the other side. And when she was younger, she was able to touch it when she was growing up. And one time she locked herself in there. So we were scared. My fiance was able to open it. And from there on out, we decided to switch it around because we didn't want her locking herself in her room. She was getting curious. She was walking and talking and
That's what 3-year-olds do. They walk and they talk.
yes, ma'am.
So when that officer came to that location, front door is locked and that bedroom door is locked. Yeah, and it was locked. So the 3-year-old can't get out. So let's say there's a fire that happened. Guess what? Number one, nobody's going to know the 3-year-old is there. Maybe the 3-year-old stays asleep. And the 3-year-old, if they have the wherewithal to try to get out of their room because there's a fire, they can't get out because you and your fiance have reversed the locks.
It was for her safety, Your Honor.
No, that's not for her safety. Let me ask you, do you all have reverse locks on your doors?
No, ma'am.
But it would be for your safety.
I just didn't want her locking herself in her room anymore. That's what scared me.
All right, and let's move on to your boyfriend, Adam Hernandez. How well do you know him?
Very well, ma'am.
What does that mean? How long have you known him?
We've been together for 3 years.
For 3 years?
Yes, ma'am.
And how old is your daughter? 3.
She's 4 now.
All right, but she was 3 then?
Yes, ma'am.
So that means that you went from one relationship to the other. If your daughter is 3 years old and he's not is he the biological father of the 3-year-old?
No, ma'am, he's the one that stepped up.
All right, so you went from one relationship, you have a 3-year-old, and then you're in a relationship, lickety split, with some other guy. And this is a 3-year-old daughter?
Yes, ma'am.
Right. And Adam Hernandez, did you do a background check?
No,
All right. Do you know if he has any criminal history?
he doesn't.
How do you know?
I mean, just because he's told me everything he's done in his past, everything that he's gone to court for, so nothing on his record.
Oh, gone to court for what?
Well, he's
been
been
charged
charged
with
with
this,
this, Judge.
All right. And what else? So you're just taking him at his word.
He's from.
And have you talked to any of the previous girlfriends, or if he's been married before, have you talked to them to find out why the relationship broke down?
Yes, ma'am.
Oh, you talked to his previous girlfriends.
His crazy ex-girlfriend, yes, ma'am. She was harassing
Crazy
me.
ex-girlfriend. See, you know what? I will tell you from what I've noticed in this world, there's always the crazy ex-girlfriend, the crazy ex-boyfriend.
This moment is almost surreal. The defendant tries to justify trusting her boyfriend by dismissing his past partner as crazy ex-girlfriend. But the judge flips that logic back on her. Every breakup has its so-called crazy ex. What really matters is doing the homework, checking criminal records, understanding someone's past, and protecting your child from strangers in the home. It's a sobering reminder that, in family law, your personal relationships can directly endanger your child if you're careless.
And you don't become the crazy ex-girlfriend or the crazy ex-boyfriend until the relationship ends. Then they go to the next person, and guess what? That person says, oh, she's the crazy ex-girlfriend. Let me just tell you, I don't think you've done your research to have this person in your life and trusting him with your daughter. I can't do anything about that. That's all on you. Probation, this is what the court is going to do. Court is going to sentence you to 4 years deferred adjudication.
The sentence is in 4 years deferred adjudication, community service, parenting classes, random drug tests, and CPS oversight. Deferred adjudication means no immediate conviction, but one wrong move and Brown could serve time. The judge also goes further, ordering checks on the locks, employment restrictions, and mandatory parenting education. This isn't just punishment, it's an intervention designed to reshape her entire lifestyle. Do you think the judge struck the right balance between accountability and rehabilitation here?
There's to be regular reporting by Zoom or in person. There's to be regular random UAs. Proof of employment. within 30 days. There should be no employment as a home health care provider or with minors. How far did you go in school?
I'm sorry.
How far did you go in school?
I graduated high school now.
All right. What are you planning on doing with the rest of your life?
Hopefully owning a business one day.
All right. So what are you doing to make that happen?
Right now, I'm just waiting for my daughter to start pre-K, just so I don't have to stay at home and watch her anymore.
All right. CPS compliance. I'm going to want field visits one time per month until further notice. And probation, please check on the 3-year-old and check the locks on the interior doors. There's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, 100 hours will be waived. The remaining 100 hours will be waived if you obtain some higher level of education or if you're in trade school. Probation, is there anything else? Yes, regular random UAs. All right, is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we're going to go off the record. You need to start putting your child first. Do you understand?
Yes, ma'am.
Here, the judge drives home the real lesson: a 3-year-old depends 100% on the parent. By bringing random people into her daughter's life without proper background checks, Brown risked exposing her child to danger. The courtroom isn't just punishing her, it's giving a reality check on what responsible parenting looks like. This is a warning not just for Brown, but for anyone watching. Kids can't choose who enters their world. You do.
I've been doing that ever since the day. I
All
got
right, because
arrested.
3-year-old can't take care of themselves. 3-year-old is 100% dependent upon you. And do not bring random people in your child's life unless you've done a background check. This is what sometimes parents don't understand. You know this guy. She doesn't know him. You're bringing a complete stranger in your child's life. That needs to stop. You understand?
Yes, ma'am.
All right. If you have any questions about anything, let probation know. If you feel as though they're not addressing it, you can always come back to the court. Do you understand?
So, let's recap. A mother left her 3-year-old locked in a room to save 10 with a coupon. The court weighed the facts, the excuses, and the risks, and handed down a 4-year deferred adjudication with strict conditions. This case highlights a core truth of the legal system: child safety will always outweigh convenience, excuses, or financial savings. What do you think? Was justice served, or should the punishment have been harsher? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.